Good morning. First thing I want to do is thank all of you for being here this morning. I know that you're all busy people. You have other things that you might want to be doing other than being in court, but I really appreciate you being here. And I know that everyone that is present for the trial also appreciates it. Today's case is a criminal case, and it is called Cowlitz County or State of Washington versus Michael Crane. And the state has charged the defendant with the crime of assault in the 4th degree. And Mr. Crane has entered a plea of not guilty to these charges. And in fact, he is presumed innocent as he sits here today. The filing of the charge itself is not evidence that in fact he did anything wrong. Cowlitz County is represented by Deputy Prosecuting Attorney Toby Crowell. And Mr. Crowell, if you could please introduce yourself.
Good morning, my name is Toby Crowell. I work for the prosecutor's office, and this is our Rule 9 intern, Russell Lutman.
Thank you very much. And then Mr. Crane is representing himself. Mr. Crane, if you could please stand up and introduce yourself to the jury.
I'm Mike Crane, live in Castle Rock, and I'm retired. That's about all I've got to say.
Okay, thank you so much. We intend to complete this case today, and we're going to have it submitted for the jury's deliberations by the end of the afternoon. So this is how we're going to start. We're going to start with what's called the voir dire, and we're going to proceed to select a 6-person jury. Now, during the selection process, the attorneys and I are going to be asking you some questions. And the reasons that we're doing that is that we want to make sure that we have the best unbiased jury that we can. So right now, what I need everybody to do, please, is stand up and raise your right hand. And then the clerk is going to administer the oath.
Do each of you solemnly swear to truthfully answer all questions asked of you by the court or counsel relating to your qualifications for acting as jurors in this trial? If you agree, answer, I do.
I do.
Thank you so much. Be seated. The right to a jury trial means the right to an impartial jury. It's important that all jurors decide the case based on the evidence that's presented during the trial and on the instructions on the law that I'm going to give you later this afternoon before you go into deliberations. When the attorneys and I ask questions, it's to make sure that you're able to put aside any preconceptions that you might have and decide the case based just on the evidence you hear today and any pictures or exhibits you see and on the law that I'm going to give you before you go back to deliberate. After the attorneys and I ask our questions, each side is going to have the opportunity to exclude up to 3 jurors. Those are called peremptory challenges. And it means that the attorneys don't have to have a reason for these challenges, and the decisions are going to be indicated privately so as not to embarrass anyone. So at this time, I'd like to begin by asking some general questions to all of you who are here for jury service. And if you would answer the questions yes or probably yes, and then please raise your paddle. I'll call on you, I'll ask your name, and then I may ask some follow-up questions, or the attorney may ask some questions. So the first question I have, has anyone heard of this case before? When you were in the lobby being called in, did you hear anyone discussing this case? Do you know Mr. Crane? Do you know either of the attorneys that are sitting here today? Now I'm going to read some of the potential witnesses. And again, if you know any of the witnesses, go ahead and raise your hand. Do you know Officer Jeff Gann from Castle Rock? What about EMT Stacy Poff? That's P-O-F-F. EMT Kirk Huda. Does anybody know him? Finally, Deputy Bowman. Does anybody know Deputy Bowman from the Sheriff's Office? As I said earlier, the defendant has been accused of assault in the 4th degree. Have any of you had any personal experiences of this kind? Number 10, and what is your name, please? And I need you to speak up loudly, please. Okay, thank you. And is your personal experience going to prevent you from being able to be fair and unbiased today?
I don't think so.
Okay. And who else raised their hand? Yes, ma'am, number 7.
Gordon.
Okay. And I'm asking you the same question. Is your experience going to prevent you from being able to be fair and unbiased today? I'm sorry? So you think you might have an issue as far as being able to be impartial today?
Yes.
Okay, do any of the attorneys have any questions?
No, Your Honor.
And you are juror number 7?
Yes.
Okay. Is there any reason I cannot excuse her?
I don't think so, Judge. If she doesn't feel like this is a good fit for her, I don't object.
Okay. And do you have any objections?
No.
Okay. You'll be excused. Go ahead and take your paddle. And I believe is there a box there she can put it in? Okay. You're excused. Anybody else? Is anyone else going to have an issue or as far as assault in the 4th degree? Okay. Do any of you have any personal experience in the law and justice field? If so, raise your hand. Now that would include police, courts, attorneys, corrections, probations, any of those type. Yes, sir, number 12.
I'm a bail bondsman, bail recovery agent.
And that certainly would be in the law and justice field. Sir, is that going to prohibit you from being fair and unbiased today?
No.
Okay, thank you, sir. Anybody else? How about any relatives? Do you have any relatives, any friends that are in criminal justice field? Okay.
Judge number 14.
Yes, thank you.
Just a recent ex who's in the Clark County juvenile detention.
Okay, thank you. And what is your name?
Yvette Peacock.
Thank you. And is that going to prevent you from being able to be fair and unbiased today?
No.
Okay, thank you. Number 2. Your name, please? What's your name?
Schultz. Does coroner count?
I think a coroner would count. I think that would be in the law and justice. A little after the fact, maybe.
Yeah. That's father-in-law.
Okay, and would that prevent any issues for you hearing a trial today?
I don't think so.
Okay, thank you, sir. Anybody else? Okay. After we've heard all the evidence, I'm going to give the jury detailed instructions on what the law is. I'm going to give you the legal definition of what assault in the 4th degree is. I know we all think we know, but there is a very legal definition that I'm going to want you to go over. I'm going to go over how the defendant is presumed innocent today as he sits here, how the state has a burden of proof, and they have to prove each element of the charge beyond a reasonable doubt. These instructions are written out for you. You're going to take them in the back if you're chosen to be on the jury. I read them to you. You have a copy to refer to so that everybody is all on the same page when you're back deliberating. By that, I mean you're going to be deciding the case based on my instructions of the law that I'm going to give you. And this is going to be regardless of what you personally feel. I need to know that you're actually going to go by what the law actually is. We're going to decide this by the end of the day. So is serving on a jury going to create a substantial hardship for anyone if it's a one-day jury? And if it is, I want you to raise your hand. Yes, number 8.
Jessica Bolton. I'm my mom's only caregiver, and she has appointments today that nobody else can take it to.
Okay, I'm going to go ahead and excuse you.
I don't object, Your Honor.
Okay. Do you have any issues, sir?
No.
Okay. Number 9.
Thank you.
I also am a caregiver, and my client just had surgery on Wednesday, and I'm his only caregiver.
Okay, are there any objections?
Not from me, Your Honor.
No.
Okay, you may be excused. Anyone else? Ready. Is there anything else about the case that would cause anyone to begin the trial with any prejudice one way or the other today? And don't be embarrassed, because if it's a fact, it's a fact, and we'd like to know that at the beginning. Finally, do any of you know any reason why you should not be a juror today? When you checked in, your names were drawn in random order. And so what we need to do now is we're going to go ahead and just name the jurors.
No, we don't do any of that.
Okay. Sorry, I haven't done a trial since we started COVID, so this is kind of new for me too. Okay, so at this point, we're going to have the attorneys ask any questions they might have. And we're going to start with the state.
Okay, good morning. So jury selection is about Mr. Crane, the defendant, and the state picking the jury that would be best suited for this case. So we'd like to ask some questions just to see who would be best suited for the case. What we're not looking for is anyone that might have a problem either with the defendant or with the prosecutors or police officers that would make them one side start out with a head start. So in this case, the judge already mentioned that the defendant, as he sits here today, he's presumed innocent. Meaning as you walk in here, he is as innocent as anybody else, and the law presumes him to be innocent. Juror number 1, have you heard that before, that people are presumed innocent? Okay. And as you sit there, do you think, well, I wonder what he did, or I wonder what happened? Or that's great. That's the right attitude. He's presumed innocent until the state proves, if the state proves it beyond a reasonable doubt. Is that correct? Any problems with that, or does that seem fair and reasonable? Be hard for someone to prove their innocence, right?
Possibly.
But when someone's faced with a crime, it's only fair that the prosecutor, that the state, that the police have to bring the evidence forward to show it.
Absolutely.
Okay. Does anyone disagree with juror number 1, thinking that, you know, as Mr. Crane sits there, he must have done something wrong, and I'm going to hold him guilty no matter what? Does anyone feel that way? Excellent. Good. In that presumption of innocence, and I'm going to ask you, juror number 2, you're related to the coroner. Have you been involved in any of the cases that have, like, paid attention to the cases involved the coroner, or watched him testify at all? Have you been part of the criminal justice system before? Have you seen any cases happen, or been a juror?
I've been dismissed before.
Okay, so some things that you dealt with were dismissed. Anything about that experience make you feel like, well, you know, against Mr. Crane or against prosecutors? Okay. The presumption of innocence, the judge will instruct you, exists until and only until the state proves a case beyond a reasonable doubt. Do you feel like that's a fair thing, that it should be a high burden that the state have to prove cases beyond a reasonable doubt? It's not like a 51 to 49 thing. Yeah, you're good with that. All right. Does anyone disagree with juror number 2, thinking, well, you know, the civil cases are provided preponderance of the evidence, 51-49. But someone's, you know, it's charged with a crime, it should be a higher burden. Does everyone agree with juror number 2 that that's a good thing, and they're not going to have, you're not sitting here thinking, oh, I always thought that beyond a reasonable doubt was dumb. If they're charged, they're guilty. He's not. He's presumed innocent until proven beyond a reasonable doubt. Thank you, sir. Juror number 3, is that, sir? Now, Mr. Crane has a right to represent himself. Right. He's choosing that right today to represent himself. And that's a right that he has. We don't have to get a lawyer. If you don't want a suit, you don't have to have a suit, all right? If I could wear his outfit, I'd be wearing it too. But he has that right to represent himself. Does that bother you that he doesn't have a suit over there?
Not at all.
Okay. And can you also, on the same thing, the judge will instruct you that sympathies aren't part of the courtroom. Like, decision-making is based on facts and law and applying facts to law. So the court's going to say you shouldn't have sympathy or concern for what a sentence might be when you find someone guilty. The state either proved it beyond a reasonable doubt, and if we have, they're guilty. And if we haven't proved it beyond a reasonable doubt, then you find him not guilty. And the fact that he has just chosen to represent himself shouldn't be a factor to weigh into the jury. Any sympathy that, you know, he doesn't have someone that went to law school over there wearing a suit representing him. That shouldn't be a benefit to our side, and it shouldn't be a detriment to him. It should be nothing in this case. Can you agree to put that whole issue to bed, that that's his choice? Any other thoughts about that as I kind of talk to you about that? It's a little bit different. You expect to see another tie over there or a jacket, right?
He can represent himself, that's fine with me.
Excellent. Anyone have any thoughts or feelings about that or disagree with juror number 3? It's his choice, his right. He has a right to go to trial. He has a right to represent himself. He has the right to be presumed innocent and have us prove it beyond a reasonable doubt. Those are all rules that we operate in here. Juror number 14.
Just a question.
Yes.
Does his choice reflect inability to pay the cost for an attorney, or are there public defenders that would not charge him?
Yeah. So essentially in the system, you can ask for a public defender, you can go hire an attorney, or you can say, I have a right to represent myself.
Okay.
And I don't want to. Right.
It's not a situation where.
Yes, if you can't afford an attorney, the court appoints an attorney, and that's true. Juror number 4. I'm going to ask you, who does the law apply to? Everyone. So does it apply to people that are rich? Does it apply to people that are older? Does it apply to people that have good jobs? Okay. And as the defendant sits here, the law applies to him as it does to me, as it does to you. Is that how you view it? Does anyone disagree? Does anyone think like, well, once you reach a certain age, you just had a bad day. You're a little bit older, or you're got a good job, you're a good person, you should be given a pass because you have a good job, you're a good person, you volunteer in the community. That doesn't ring well, does it? Right? It applies to everybody fairly. Does everybody agree that we all have to follow rules? And if we break rules, then there's consequences when we break rules. Mr. Bail Bondsman, along that line, you deal with people accused of crimes, right? What juror number were you? Was it 12? I was going to guess 12. This is like trying to remember the concentration game of the cards. Where's it for? Does that make you feel any different towards the defendant? That your job is actually kind of is helping defendants face charges and get out of custody pre-trial. Does that experience hurt him? Do you think you can be fair to him, even though you have to deal with some people that probably at times are disappointing in your field? And probably also in your field, sometimes you meet some nice people that you helped out of jail that were innocent. Yeah, plenty of times where there's charges and then charges get dismissed, right? What about that for me? If you're me and you're like, well, geez, prosecutor, you guys there's been cases brought and they didn't stick, and does that hurt me? If you were me, would you be concerned about having you as a juror because of your job?
I don't think so.
So we both start out with you, just like a clean slate, can be fair to both sides. Juror number 5. I got it right. All right. So when you think about an assault, what does that mean to you? An assault happen?
I would think some sort of physical altercation.
Okay. So if the judge tells you that there's actually multiple different definitions of an assault, one could be that someone touched you in an offensive way, that's an assault. If that's one of the definitions, that someone touched you in an offensive way that was harmful, can you accept that as a definition of assault?
Yes.
If the judge instructed you that someone could take a swing at me and I could duck and miss, and that they didn't actually hit me in the face, but they tried, and their intent was to hit me in the face, and the fact that they missed or I'm quick with my feet, that could be an assault. Even though they missed and I didn't get punched, does that definition of assault, even though that's a law in Washington, is that something where, well, I don't think I like that, I can't follow that?
I think if it's the definition of the law, it's the definition
Does anyone disagree with juror number 5 that, well, if you're charged with assault and you missed your blow because the other person, because my swing was bad, or because the other person ducked, that because you didn't make contact with what you intended to do, I don't want to find someone guilty of assault because they failed to accomplish that goal, even though the law says differently. Does anyone have a problem with that? That you actually, if it's going to be an assault, you better land the blow or I'm going to find someone not guilty, right? Juror number 6. Okay, there's also a definition of assault that says that you could not intend to hit me. Like someone could come up to me and intend to scare me about being hit. That they could just go like this and swing and then stop with no intent of punching me. And I'm sitting there going, ah, and then they stop and don't hit me. And then legally, that's an assault because they intended me to feel the fear of an immediate hit or strike.
Yeah, if it's stated there in the law, I can see that, just kind of like it being the same as what could be a threat as well.
Mm-hmm.
So I'd be fine with that.
Does anyone have a problem with that law? That you're going to be looking at the law. In this case, the judge is going to read you this during instructions. They're going to say an assault can be 1, when someone strikes you and it's offensive, 2, when they intend to strike you and miss, or 3, when they intend you to fear an assault that's coming your way. Does anyone have a problem with that law? Yes, juror number 16.
I guess because I don't know what assault 4 is.
Right. So
I see if it's a threat. I live in South Carolina, I see that every day.
Yeah, a threat's not an assault, but an action that leads someone to believe of immediate harm. Exactly like, hey, I'm gonna punch you. That's disorderly conduct. But if you go cock your arm back and you go to swing at somebody, that's an assault because you place someone in immediate fear of being hit. So that doesn't sit right with you?
No.
Okay, that's fair.
Because I see it every day.
So the fact that you see it every day, you don't think it should be a crime?
I guess because I don't know the true definition of an assault 4.
Okay.
Is it a push, is it a scare? I don't know.
Sure, that's fair. And what you're doing right now is exactly the right thing. Raise your paddle, like the Donahue show, and a few of you probably remember the Donahue show. You walk around and people raise their hand and get the microphone in the eye. That's what we want you to do, is just tell us how you feel. And it's like, this doesn't really feel right. So if the judge instructed you that if somebody attempts to injure another but fails, it could be an assault, do you think you could follow that jury instruction? Or because where you live, you see that all the time. It just is like, geez, everyone would be in jail for assault 4. And that would be a difficult law for you to follow.
I don't know how I feel about it.
Okay, that's fair, that's fair. Okay. All right, I think I have juror number 9. Am I right, 10? Man, okay. So the judge is also going to talk to you about direct versus circumstantial evidence. So when we talk about direct versus circumstantial evidence, direct evidence would be you observed me go pick up that liquid over there and move that liquid away. That would be direct evidence, that you saw me directly do it. Circumstantial evidence would be you were right there, I'm the only one in the room, you left the room for 2 seconds, and then it's gone, and I'm in here by myself. So circumstantial evidence, you make a reasonable inference. You know what, I think that prosecutor moved that bottle. There's 2 seconds, there's no chance for anyone else to get there, now the bottle's gone. I'm gonna make a reasonable inference that the prosecutor moved that bottle. And the judge will instruct you that circumstantial evidence is as powerful as direct evidence, if you believe the evidence. You have a problem with that law. You can use reasonable inferences. So someone's demeanor, potentially, or hostility or anger can be circumstantial evidence of their mental state. Does anyone disagree with that? That, it has to be seen by somebody. You just circumstances and reasonable inferences. I don't believe in that. I've heard of, that was just a circumstantial evidence case. Anyone have a problem with that or any comments? Let's see, I'll go to juror, I'm way out of order. I think 14's next. Okay. 13, do we have 13? That's the one? Okay. After 13. Do you have, yes, sir, any experience with police officers, either negative or positive, that would impact your belief in listening to evidence here, have a hard time listening to evidence based upon any prior contact with law enforcement?
I have different contacts for my speeding ticket and stuff like that. I had to talk lie in court for a speeding ticket. I mean, had that kind of negative response from them.
Sure.
Plus, a lot of YouTube videos these days.
Yeah.
I see a lot of negative things about law enforcement.
So does that put me at a disadvantage because there's an officer testifying in this case in your mind?
On your side, yeah, the state, yes, I'd say it puts you at a disadvantage.
Okay. Do you think that there's probably some good police officers that are honest? Yeah. And there might be some situations where they weren't, like your speeding ticket.
Sure. I've had friends that were police officers too, long time ago, and 10 years into it. That's about it.
So could you put that experience with your speeding ticket aside and just listen to the evidence and the questions and be fair to both sides in this case?
Yes.
Does anyone disagree with juror number 13 that there's something that they had with, if an officer testifies, like, because of this experience, or maybe a police officer saved your life once, or your kid's life, in a situation where they came in to rescue and help, and that Mr. Crane's at a disadvantage if I have. We don't want that. We want us both to start out equally. Does any experience with law enforcement give either side a disadvantage? Ma'am in the back, are you at 14? 14, yes. What about EMTs? Is anyone, you're gonna hear testimony from some emergency, like ambulance kind of drivers that respond to 911 calls. Any experiences with those that would give either side an advantage or disadvantage? Okay, all right. Anyone else have any experience with EMTs where it was super positive or super negative that is going to give either side an advantage or a disadvantage? I'll go back to, do we have juror number 7 still here? No. Okay, has anyone been a prior juror before and sat on a jury?
I was an alternate juror.
You were an alternate. Was it a criminal case or a civil case? Okay. And did you deliberate or did you get excused? Anything about that experience that makes you? Do any of you jurors know each other that are still here that haven't been excused? Okay. I'll go back. Oh.
I know juror too.
You know juror too? Okay. All right. And is there anything? Yeah. Hey. About that, like if you guys, do you have, and this is the reason we ask this, that if you guys are in there deliberating, you have a duty to discuss the case. Is there anything about your guys' relationship that might make you two not the best to be on the same jury with?
I don't think so, no.
Okay. Okay. Juror number 15? Yes. So the judge will also instruct you as if the state proves this case beyond a reasonable doubt, that you have a duty to return a guilty verdict. If I prove this case that he assaulted somebody beyond a reasonable doubt, would you have a problem finding him guilty?
No.
Okay.
If you prove he was guilty, then no, you not have a problem.
Okay. And I don't think I've talked to you, anyone else? I think I've talked to everybody. Anybody else think that? If I prove this case beyond a reasonable doubt, because he's pro se, because he looks like a nice guy, would you have a problem returning a guilty verdict? And if you do, that's what we want to know. But the law says if I prove it beyond a reasonable doubt, you have a duty to convict. If I don't prove it beyond a reasonable doubt, you have a duty to acquit. Does anyone have a problem with prosecutor, with an assault for charge, with a defendant who's pro se, with having any sympathy because of a prior speeding ticket or being a bail bondsman, or anything where you're like, you know what? Sorry, you're not getting it guilty no matter what. Juror number 11.
This may not be relevant. You asked if we had served on a jury before. In 2019, I was part of a jury pool
Mm-hmm.
on a capital
Murder?
murder case.
Mm-hmm.
Took 2.5 days to go through the jury selection trial, or process. Fortunately, I wasn't asked to serve because I could not have given a guilty verdict, even if you've been found guilty, as you're saying, beyond a reasonable doubt. Having gone through that whole process is kind of colored how I'm looking at court proceedings. Does that make sense?
It does. It does. I'm just gonna assume you didn't believe in the death penalty and you didn't want to make that decision. Okay. That experience, would that affect you? We're talking about an assault 4th degree, which is not, it's a,
And again,
Yeah.
I see suggested we don't know what assault for is
Sure.
exactly. It's just the, no, I think I would be able to, I think I'd be able to work on this one, yes. It's just the leftover emotional baggage, I guess, from that previous criminal trial.
that's understandable. Do you feel like you could be fair to both Mr. Crane and also to the prosecutor's office?
I believe I could, depends what the law says.
I don't have any further questions, Your Honor.
Okay, thank you. Mr. Crane, this is your opportunity to go ahead and stand up and ask any questions you want to ask, and you have about 15 minutes if you'd like to take it.
Okay, thank you very much. Hello, and I'm not gonna ask as many questions, I have no idea what to ask, but, I think you're all intelligent people, and when you hear my side and their side, you'll make the right decision. And so, as far as I can see, any one of you is fine with me. So that's all I've got to say, is just listen to both sides and just don't automatically believe what the police officer is saying because he's a police officer. I could tell the truth just as well as he can. So just please listen to what we have to say and make your decisions, and you'll know what's right or wrong. Thank you.
Thank you, Mr. Crane. Now that the attorneys and I have had a chance to ask our questions, we're going to proceed to the final step of the jury selection process. This is where the attorneys get to use their peremptory challenges to excuse up to 3 jurors each. And so when you're ready, both parties, you may approach the bench.
Should I come up, or they're all fine with me?
Come on up. Yeah. thank you.
Thank you.
Go ahead and be seated again.
So that's the names I named.
That's the ones that are seated, that are gonna stay.
Okay.
Read their names and have them stand.
The ones I named,
Read the highlighted ones, have them stand.
and then everyone else leaves. And then we're gonna take that break in a few minutes, right?
Okay, thank you very much. What I'm going to do at this point is I am going to name the jurors that are going to be on the sixth panel. And so when I name your name, I want you to go ahead and stand, please.
Donna, do we just use numbers, not names?
Oh, yeah, numbers.
Okay, thank you. Juror number 1, could you stand? Thank you, sir. Juror number 3, go ahead and stand. Juror number 4, thank you. Juror number 5. Juror number 6. And juror number 11. And you are actually going to comprise the jury, and so everyone else that is here may go ahead and leave at this time. Thank you for your service. Make sure you still call in case you get any additional calls, and go ahead and leave your paddles in the back. Yes. Okay, now that you are actually going to be on the jury, we're going to swear you in one more time. So please go ahead and raise your right hands, and the clerk is going to give you the oath.
Do each of you solemnly swear that you will try this cause and bring forth a verdict according to the law and the evidence presented to you? If you agree, answer, I do.
Okay, thank you. Go ahead and be seated.
Brittany, do we go ahead and take the recess now?
Okay, what I'm going to do at this point is we're going to take about a 10-minute recess. The bailiff is going to take you to the back, show you where the jury deliberation room is, and then we will get started.